Namaste Sakshi, Manasakshi. I am Priya Goteti. Welcome to Immigration Special Talk Show with Attorney Bhanu Illindra. Please note that Sakshi TV now has 5 immigration shows every week on Monday with Somiradi Law Firms, Tuesday with Kaveti Law Firms, Wednesday with Prashanti Reddy, Thursday with Chand Parvataneni, and Friday with Bhanu Illindra. Today is a special show with Bhanu Illindra. Please tune in to ask your questions, and if you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is just not a legal advice and for general information purpose only. Sakshi TV or its agents are not responsible for use of this information. If you need any special legal advice, please contact the attorney directly, which is Mr. Bhanu Illindra from Bhanu Illindra Law Firms. So he's specializing. He has a specializing on employment-based visas, especially on H-1B and L-1s, and for businesses and individuals. So if you have any questions, please contact the attorney directly. So without any further delay, let's welcome Bhanu Illindra Garu to our show. Hi, Bhanu Garu. Welcome. How are you?
I'm fine. Thank you, Priya. Thank you for welcoming me back into the show.
It's pleasure to have you, Andy. So today our topic is DH's final rule on H-1B modernization. So can you just provide us a summary on what exactly this DH's final rule is about, and what are these changes regarding H-1B modernization?
The H-1B modernization rule, final rule, is mainly dealt with 3 to 4 issues with H-1B program and other non-immigrant visas. First thing is they dealt with the lottery registration process, which has been already passed in the month of January of this year. What they did is they passed the final rule in 2 phases, in 2 parts. In first part, they dealt with the H-1B lottery registration and also with the H-1B filing fees and other fee increase and all those things, and also with the flexibility of H-1B start date filings with the cap cases. These are the 3 major issues which they have dealt with in the first phase. In the second phase, which was passed yesterday, and they dealt with the actually changing the criteria to determine what position qualifies as a specialty occupation and who qualifies as an US employer for the purposes of petitioning H-1B to their employees. Okay, and also along with that, they actually discuss. They have given some kind of an explanations about who qualifies as an H-1B cap exempt organizations also, and what they look into that aspect also. They made some changes towards those requirements also, and along with that, they removed they actually required they extended the F1 students a cap gap validity, just not up to September 30th of that particular fiscal year. They extended to the next fiscal year, the relevant fiscal year, until April 1. What I'm trying to say is now F1 students don't have to worry about not working if the case is pending beyond September 30th of that particular year, because their cap gap is over after their OPT or a STEM OPT. They will be able to work until April 1 now. So USAs have enough time to adjudicate, and while H-1B is pending, they'll be able to work until April 1. That solves their immigration status as well as their work authorization issues for them to continue to work in the US on F1 visa. So that is one good thing happened in these regulations, and how deeply these regulations have been changed is what really matters. How it's going to impact the real applications or real impact for H-1B, especially for the employers in the US, as well as the foreign workers who are on the H-1B visa in the US.
Sorry to interrupt, Bhanu Illindra. So one question, is this applicable only for the new applicants who are filing for H-1B, or for renewals too? Is this applicable?
To everyone, even the cases that are pending as of today. Okay, in this case are pending as of January 17th, 2025, the day these regulations are going to come into effect, even those cases are applicable and they are subject to these new regulations. Okay.
Okay.
And I believe many lawyers already spoke what are the main requirements for this particular, what are this and everything. We have seen, and I mean, it was really, I was surprised to see how it was spinned off in the Indian national media, especially in India, telling that this is actually a positive thing for the US employers and the H-1B workers with these regulations. Uh, Unfortunately, it is not. That is a, I would say, that is a very misunderstood spinning of the regulatory interpretation and the requirements what US is actually looking into. See, I think it's a good idea to discuss a little bit history to understand why this regulations is so important, why we are discussing, why we are having this special show also today, talk show also today, specially scheduled, because to bring the awareness to the people what to expect with these new regulations, you know, and
Mhm.
and sometimes it may be good, it may be bad, but it's important for them to understand even if it's bad is coming, then only they can prepare how to face those issues. That's why we're doing this. And there is no positivity with these regulations. There is nothing to do with the what are the statutory requirements with these regulations. They're codifying the memorandum or internal policies which they were following prior to 2020 IT Serve Alliance decision made by the district court in Washington, D.C. And what they're trying to do is they're going to bring back again the requirement of establishing the contractual relationships between the employers, vendors, and the clients, especially if the individuals, H1B workers, look into the third party companies, third party clients. And see, you have to understand this H1B program is utilized majorly by the consulting firms, whether it's in IT or whether it's in healthcare. These are the two industries which uses H1B program more than any other industry. And healthcare also and IT industry also, most of the employers who utilize this program are consulting businesses. What they do is they actually enter into an agreement with the third party companies to provide services in a specialty occupations. And for that, they bring in these H1B workers because these people are very highly skilled and highly qualified to do those jobs for their clients, for their businesses. Now, statute does not require to establish such kind of relationship. Statute only requires to show the nature of the business of the employer and show the requirements of the individual in a specialty occupation. That's what the statute requires. But now they are going. But in 2011, Newfield memo was passed, which USCIS obnoxiously demanded the employers to provide the documents showing the relationship between the employer, the client, or any parties involved in between, and also to show the requirements of the client so that whether the position qualifies as a specialty occupation or not. And that way, we have seen thousands and thousands of cases have been denied, saying that those positions does not qualify or this individual does not qualify for H1B. People who stayed in this country for 10, 15 years also lost their H1B visas, H1B status, and they have to revert back to India or from whichever country they have come from because of those draconian application of those or the draconian interpretation of those internet policy memorandums or regulatory interpretation by the USAs in the past. It has become so difficult that some organizations they filed a lawsuit against the USCIS, and then court ruled on the statutory basis saying that this is not legal for the USCIS to do that. That's why from 2020 it became very easy for the employers to hire an H1B workers as long as they can show that their nature of the business and the bona fide requirement they have to hire an H1B worker. Now, again, USC is going back to prior to 2020 requirement. Now they're codifying it through regulation and making it legal right now. Okay? So they're trying to overrule the decision given by the court. Now they will demand you to provide the client letters. If you don't provide, they can deny the case. And they're making your participation not really saying, but saying that your participation in site visit verification mandatory. And if you don't participate, very likely they're going to deny or revoke your H1B petition.
Okay, so here I have a question. I'm hearing that there's something regarding location change. So is there anything that should be worried for remote workers on H1B?
That is always a worry, because that's about the whether you are whether there is a material change in your employment, in your terms of your employment or not. And if there's a material change, then you have to file an amendment to the H1B petition timely. And if you don't file an amendment, then worker is violating his or her status, and they'll be losing their benefits, and they have to leave the country. And employers also will be found in violation of the regulations, and the employers will be sometimes can be stamped with some fines or some bars or anything like that. So it's always there. The main concern here is whether the requirements for H1B occupation, H1B specialty occupation, are going to be changed. What they're going to look into it, and also they change the even the specific criteria that will be considered for the purpose of determining whether the position qualifies as a specialty occupation or not. I'm talking about specialty occupation. What is specialty occupation means? Any position that is in a particular field of endeavor requires at a minimum bachelor's degree or its equivalent to perform the job duties competently. That position qualifies as a specialty occupation. Okay, that is general meaning and understanding what is a specialty occupation is. And that is going to change a lot with this regulation requirements. Now they're going to talk about what degree you have and whether the degree is related or not. What is the logical connection, and why if you require multiple degrees for one position, they want to ask you how all those degrees are related to each other or correlated to each other, to see how the position qualifies as a specialty occupation or not. And the criteria also has been changed. Before, there was a 4-point criteria suggested in the regulations, in which if you meet any one of those criteria, the position may qualify as a specialty occupation. Now, that criteria has been reduced to 2 or 3 now, and you have to prove to the USCIS that your position actually meets all those 3 criteria. That's going to increase the burden on the employer on how to document, how to prepare the case, how to justify that. And under those circumstances, we have seen past thousands and thousands of times USCIS always abusing the discretion and imposing the standards more than preponderance of the evidence, and going with the clear and convincing evidence standard, which is higher standard required for the employers to prove the position qualifies as a specialty occupation. So,
So sorry to interrupt, Bhanu Garu. What are those 3 criteria that you are mentioning it for specialty
uh,
occupation? Like out of 4, the 3 mandatory requirements that are required for the employer to prove.
they combine the 2 and 3 together, and I will just give you a brief. I'm sorry for that. Sometimes it doesn't come in my mind all 4 together. Just give you that. Just a second. Sorry for that.
Yeah, not a problem. Meanwhile, I also have a question. Like most of Indian students would be like doing BTechs engineering from mechanical, electronics, different
Mhm.
backgrounds, but they are in US on H1B from
Mhm.
past 5 years, 10 years, doing on Java, DevOps, whatever the technology it is. So, will
Mhm.
there be anything saying like, okay, you're from mechanical or you're from electrical, but you are on Java, you are on DevOps, Azure. So, will there be any problem with that?
Definitely. Definitely, those people are going to face more RFEs, questioning how their education is related to the field in which they are working. Okay. And but it doesn't mean that it's the end of the road for them. Okay. If they have a competent lawyers, they'll be able to show how they qualify for the IT position, although their basic degree is in mechanical engineering or civil engineering. See, most of the times we have to show. That's the reason why the regulations require you to show the bachelor's degree or its equivalent in a specific field of endeavor. Its equivalent means it doesn't have to be another bachelor's degree. It can be equivalency of equivalent of experience or a training, or a combination of experience and training, or a combination of experience education, or a combination of education and training, or a combination of education training and experience also. Okay, so if you have all these type of combinations also together, if you can equate to a one particular a degree which is in a specific field of endeavor in which you intend to work or related to that particular field of endeavor, you may qualify for that H-1B again. So if they already have an H-1Bs, probably they would have faced this issue in the past with the USCIS, and and they would have had enough documentation to show that how they qualify for that position. Okay,
Mm-hmm.
but if they don't, then that's going to be a problem. Okay, and also you said they worked for already for 5 years in the same position. Those 5 years can experience, which is if it is progressive in nature, we can use that to get that equivalency towards the IT background or a computer science background, depending upon what position they are in. You know, so those are the things which we can easily do that. But that is a very good question, and that is one major issue which we're going to see with these regulations. That's why I was surprised to see in many media channels in India saying that Biden had been eased up the H-1B regulations to hire foreign workers. In the US, I was a little bit surprised on what basis they are saying that. You know, I'm not saying they're completely wrong about it, but it is not entirely true also. You know,
Yes, so I
and
get it. Like for F1 students, it is helpful because they have more cap.
exactly.
So while we are talking on F1, I know we are talking on F1 and H1. For
Mhm.
H4 EADs, before we used to have something like 540-day rule, like 6 months, 540-day rule. So is this cap applicable for them, like cap or, the 540-day rule
540-day
still?
rule is not applicable to F1s. 540-day rule is applicable for the H4 dependents,
Okay.
spouses, adjustment of status application pending people, uh, and L2 and E2, E3, E2 dependents, E3 dependents, they call E3Ds, okay? E3 dependents and also people who having their adjustment of status application pending and they have an EAD based upon that, and people who are seeking asylum or refugee status in this country, they are the ones who have 540-day automatic extension of EAD. But
Mhm.
unfortunately, F1s do not have that. When F1s, when they file for a STEM OPT extension, EAD application, their automatic work authorization extends only up to 180 days, not
Okay.
for 500 days.
Okay.
And the criteria, you asked me about the four criteria, what is required, which we
Mm-hmm.
have to show the position qualifies or not, is that a the first criteria is in the past, I'm talking about the past, is that if you have a bachelor's or a higher degree or its equivalent is normally the minimum requirement for the position for which you are offering or intended to hire an individual. That is the first criteria. Second criteria is that degree requirement, that particular degree requirement is common to the industry in which the individual is intended to be hired or perform their services in that organization. Second thing, third criteria is that employer normally requires a bachelor's degree or a higher degree or its equivalent to hire somebody in the particular position for which the beneficiary intend to be hired for. Okay, and the fourth criteria is the nature of the specific duties is so complex and so specialized that knowledge required to perform these job duties is usually associated with the attainment of a bachelor's degree or its equivalent. Okay, these are the four criteria we have to, which has been stated in the past regulations, and now there has been skewed to one or two criteria. Those four things are there, but into one or two criteria because some of them are very repetitive. For
Mm-hmm.
example, baccalaureate or higher degree or the specialized duties or specialized nature, one and four somewhat similar, and that way, and so that's why they made it into two-part or three-part criteria because of that. If you meet any one of those criteria before in your argument or in your document, you may qualify or your H1B is approved for specialty occupation. But now you have to meet all of that criteria. You have to show that the position for which you are filing actually meets all of that criteria and your requirements actually meet all of that criteria. So if the employers try to address these cases on their own, sometimes they may get into trouble. It's important for them to seek help with the experienced attorneys who are immigration lawyers who are very well experienced in handling these matters and take their guidance and work with them. I think that's a very good idea thing to do for them, at least initially, to have a proper understanding how the adjudications by the USAs is going to be with these new regulations coming into effect. See, Biden administration uh, actually gave a very good I would say fruit platter. తెలుగులో మన పళ్ళు ప్లేట్లో పెట్టించామంటారు చూడండి. Like that, they have given a fruit platter to the Trump administration, which is going to come from January 2025 onwards. This is what they wanted to do anyway. What Biden administration did right now, that is what Trump administration wants to do with H-1B program anyway. There is no friend either in Biden administration, Biden admin, or a Trump admin if it comes to H-1B program. Okay, and they're going to they're going to carry with these regulations, and they're going to implement these regulations as draconiously as possible, because that is what they wanted to do anyway. And the Biden did the work for them before they're leaving.
Thank you so much, Bhanu Garu, for sharing your insights on H1B modernizations or on all these rules. And this is Priya Goteti signing off. You are watching Sakshi Sakshi. Thank you.